Okay, welcome everybody. This one is about standing. Do-it-yourself Kangaroo Courts number 21, standing. And so we're going to talk about what is standing. First of all, I'm not a liar. Well, I'm in a lawyer. No, I'm in a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything, and I'm open to any ideas. It's time to get unplugged. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. I like to think I'm maybe one of those. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Ain't that the truth? And that is thanks to our public lack of education system. Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the pigs. And that's true. Wow. My kind of people. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical, pharmaceutical, industrial complex, owns the military industrial complex, and owns the mainstream media. If you call me a conspiracy theorist, I don't trust you. Government's not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. So what is standing? Standing is a party's right to make a legal claim or seek a judgment enforcement of a duty or right. Okay? This is taken from Black's Law Dictionary, 8th edition. To have standing in federal court, a plaintiff must show that the alleged conduct has caused the plaintiff actual injury, and that the interest sought to be protected is within the zone of interests meant to be regulated by the statutory or constitutional guarantee in question. So you have to show that you have a right, and that they damaged your right, and that the court has a duty to protect that right. Basically, is what they're saying. It's like, think of it this way. If someone goes and assaults your neighbor, you don't have any right to sue over that. Okay, you can file a criminal complaint because you witnessed the assault, but other than that, that's all you can do. I witnessed this felony. Okay, that's all you can do. If it's a felony, you can file a criminal complaint, but at the end of the day, if they want to sue or to get a remedy, you don't have standing. So that's really, really important. Standing. If you don't have standing, then jurisdiction's not even an issue. Standing is an issue long before jurisdiction ever gets there. So, anyways, moving right along here, we're going to actually go through some generic documents at the end of this that I made up, where you can challenge standing, and how it was done in 4 or 5 cases here in the DFW area. And all the cases disappeared. Anyways, so standing is really important. If you don't have a right to bring a lawsuit, then jurisdiction, it doesn't become an issue. Jurisdiction only becomes an issue after standing is established. But these bought and paid for clerks, masqueraders, judges sit there and play stupid, so you have to know to challenge it. This is Rundle versus Delaware and Raritan Canal Company, U.S. Supreme Court, 1852. My opinion is, and has long been, that the mayor and aldermen of a city corporation, or the president and directors of a bank, or the president and directors of a railroad company, or other similar corporations are the true parties that sue and are sued as trustees and representatives of the constantly changing stockholders. A corporation, therefore, being not a natural person, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States, and cannot fall within the terms of the power of the above-mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. And that's Rundle versus Delaware, 1852. So, where that's important is, now obviously we've had the 14th Amendment, and that kind of turned everything on its head. But the bottom line is that corporations can only talk to other corporations, and men can only talk to other men. And so when they sue you, okay, it's state of Texas or some like there was a friend, somebody contacted me, they were getting sued. There was an action, city of Las Vegas, okay. So anything like that, that's a corporation. They don't have standing, and so that's the first thing you do is nip it in the bud, okay, and challenge standing. A corporation shall be deemed to include any company, trust, so-called Massachusetts trust, or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest. So, and then the second part of the definition is basically the same definition, except you see the underlined part, without shares of capital or capital stock or certificates of interest. And then except partnerships. Okay, so a partnership is not a corporation. That's why partnerships are really slick when it comes to having a business or something like that. But so the bottom line is though that Sestakay Trust that they like to assault you with definitely falls within the corporation because it doesn't have shares of capital or capital stock or certificates of interest, but everything else fits, so it falls under the definition of a corporation. And the corporation, or the Sestakay Trusts, okay, again, I set up trusts is one of the things I do, and those trusts, if they own land, they have to pay the property taxes, okay, because they are a corporation as found under this definition. No matter what, the corporation, any corporation, in order to be a taxpayer, has to have a taxpayer identification number. And so, as far as the IRS is concerned, but they can still tax your local city council or whoever does the taxing can tax on land a corporation. So that's why what I do is when I help people bring forward a land patent, I always tell them that they have to put it in the name of a man or a woman if they want to get out of the taxes. And that's usually the primary motivation, is getting out of the taxes. Anyways, commerce means commerce among the several states or with foreign nations or in any territory of the United States or in the District of Columbia or between any such territory and another or between any such territory and any state or foreign nation or between the District of Columbia and any state or territory or foreign nation. So again, interstate commerce, that's really the only thing that they can do. That's where they get you. But you have to understand that all of these cops are U.S. citizens. And if you're deemed to be a U.S. citizen, I'm starting to go after them for felonies under false records, okay, because they have in their records that I'm one of their U.S. citizens, okay. That's false records, and so that's a felony under 18 U.S.C. Let me see here. Oh, I closed all those out. The only ones that I have open right now, let me see. Let me see here. Okay. False entries. 18 U.S.C. 2073. That'd be the federal one. It says whoever being an officer, clerk, agent, or other employee of the United States or any of its agencies charged with the duty of keeping accounts or records of any kind with the intent to deceive, mislead, injure, or defraud makes any such account or record any false or fictitious entry. In other words, they're calling you a U.S. citizen. Okay? That's a false entry. Okay? But the burden's on you to bring up the issue. Okay? And so that's where I'm starting to go with that, as far as filing criminal complaints and start accusing everybody of that. And that's one of my, again, if you don't complain, there's no damage, So the bottom line is that once you understand, see, if you're a U.S. citizen, then it doesn't matter where you're at. Okay, they have jurisdiction. Okay, if you're a state national, it's completely different. Okay, so you have to break it off in their butt. So territories. This is oh man, I didn't put the site on this one. This is Downs versus Bidwell. I'm surprised I didn't put the site. Let's see if it's on the next one. No, it's not. Okay, yeah, this is actually taken from Downs versus Bidwell. Eliminating then from the opinions of this court all expressions unnecessary. This is 1901. I wonder if I can find that here. Let me see. There we go. Downs versus Bidwell. And we'll just go back to that one. There. Okay, so eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case, and gleaning therefrom the exact point decided in each of the following propositions may be considered as established. Number one, that the District of Columbia and the Territories are not states with the judicial clause of the Constitution, so they don't get Article 3 courts. That the Territories are not states within the meaning permitting writs of error from this court. Okay, so the territories, they're not states, so they don't get writs of error. That's after that they came out with the petition for a writ of certiorari, and so, but I think there's a case called Brown versus Texas that was from the El Paso County Court at Law. They went and appealed to the Supreme Court directly from the El Paso County Court at Law. It's Brown versus Texas. Look it up. It's like 1975 or something like that. Anyways, the Supreme Court answered it, and I think that might have been a writ of error. They don't say in there that it was a writ of error, but it was on appeal from Brown. It was on appeal from this El Paso County Court at Law. So, if you go through the federal courts, it's definitely going to be a certiorari, because I've been to the Supreme Court 5 times and through the federal courts, and it was always a writ of certiorari. So I'm looking at something, that I file in the state courts and then appeal it to the Supreme Court as a writ of error. See what happens. I haven't done it yet, but that's something that I've really been considering. Anyways, number 3, that the District of Columbia and the Territories are states, as that word is used in treaties with foreign powers. So number 1. So number 2, the territories are not states, okay, but they are states when they're used with treaties with foreign powers. So that's why when you look in the definitions under, like for example, Title 8, United States Code, I think that's immigration or customs. If you look in the definitions, it'll say that they have authority in the District of Columbia and the Territory and the states, and then it lists the states: Guam, American Samoa, and Puerto Rico. But if you go to, people think that that's the 50 states. Well, no, it's not. It's only the territories, because that's the only place that has lawful jurisdiction. If you go to Title 39, which is post office, they've been talking about post roads in the Constitution right from the beginning. And so Title 39, which is post office, if you look in the definitions there, it'll actually say the 50 states. And so that's the difference, and people have to understand that. Anyways, so then number 4, the territories are not within the clause of the Constitution providing for the creation of a Supreme Court, such inferior courts as Congress may see fit to establish. Now, the interesting thing of this is this was actually argued in January of 1901, and the D.C. Code came out in March of 1901, and then the decision on this case came out in June of 1901, and I think that the Supreme Court called up the Department of Justice and said, this is what we're going to come out with, because in the D.C. Code, it sets up a Supreme Court of the District of Columbia. And so the judges, Roberts is Chief Judge of the U.S. Supreme Court, and also the Supreme Court of the District of Columbia, and it depends on which arguments you bring will determine which hat he is wearing, and the other judges are all the same way. That's why if you bring a case through the district courts, the federal courts, that it's going to be a certiorari, and so then you're a U.S. citizen. And if you bring a case from a state, then it's different. And this Brown versus Texas case that was appealed from this county court at law, the Supreme Court answered it, and they said that's unconstitutional. So that's the important thing to understand is how this all works, and they're not going to tell you. They're nothing, don't get me going. You're going to get me going. This is a U.S. District Court, If you look in the actual act of Congress, it calls it a District Court of the United States, But this is Balzac versus People of Puerto Rico, U.S. Supreme Court again. The United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States. And so I've got that in here. We'll see it here in a little bit. Article 4, Section 3. It says that Congress shall have power to make all needful rules and regulations respecting a territory or other property of the United States, And so that's Puerto Rico is definitely territory, but and then those courts and the territorial courts or other property of the United States, that's for their slaves. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in a catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of the Washington District of Columbia, and through their plenary power, that's military dictatorship, folks, nationally governs those citizens, even when one of the several states as the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And I don't know, that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Now, if you look at what was I going to say? Oh, that Kavanaugh hearing. If you remember that Kavanaugh hearing, when Kavanaugh was appointed to the Supreme Court, they had a hearing in the Senate, and they asked, Lindsey Graham asked Kavanaugh, if they had jurisdiction over a U.S. citizen in Afghanistan. And he said, yes, we do. And they do. A U.S. citizen anywhere on the planet, anywhere in the universe, they have jurisdiction over. If you want to be free, you can't be a U.S. citizen. That's why you should always challenge standing. That's why you should always file criminal complaints for their false records. International law rule. This is taken from a book called, and this is freely available online. You just do a search for it. Actually, this Jurisdiction over Federal Areas within the States, Report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the States, Part 2, a text of the law of legislative jurisdiction submitted to the Attorney General and transmitted to the President, June 1957. Now, this is taken from pages 158 to 165. So you see the dots, that's where stuff is missing, okay? So, and you can just do a Google search and you come up with, there's two books, and there's part 1 and there's part 2, and one of them is like about 600 pages and the other one's about 1,000 pages. And and I like to do keyword searches. It's amazing the stuff you find. So money under international law is unconstitutional. This is Texas Business and Commerce Code. Okay, you got to understand the Texas Business and Commerce Code is private international law. That is unidroit. It's controlled and regulated by the Roman cult. Money means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. And so, yeah, that's money, okay? A party, as distinguished from a third party, means a person that has engaged in a transaction, made an agreement, or made an agreement subject to this title, okay? So it's transaction, okay? Those are commercial terms. An agreement, those are commercial terms. Commerce. And so remember, what's commerce, okay? Remember we talked about that. 15 U.S., Title 15, United States Code, Section 44. Commerce is between states, okay? It's not here in Texas, but they send their U.S. citizens here, and if you're a U.S. citizen, then you're in interstate commerce, and they can do whatever they want. And so if you establish yourself as a state national, they got a problem. So if you don't do something, if you don't complain, nothing's going to change. Article 6, Clause 2, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which shall be made under authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution and laws of any state to the contrary notwithstanding. So, when you demand a trial by jury, remember we talked about that not last week, but the week before last, we talked about trial by jury. That's where the jury conducts the trial. They don't want to give it to you. Matter of fact, they can't. And so they're going to tell you, well, our state codes only authorize a jury trial. Well, then under the supreme law of the land, Article 6, Clause 2, you are bound by the supreme law of the land. Now, so you either give me a trial by jury, I don't care what your state codes say or what you're authorized to do. You either give me a trial by jury or dismiss this matter. And that's what you need to do, is stand your ground, and they'll drop it. As used in this act, the term United States means the government of the United States. Now, back to this one, trial by jury. Remember we were talking about that. That's if you get past the standing, okay? If you don't get past the standing, then the case is going to go away because of lack of standing, okay? And then the challenges to jurisdiction and all the rest of it, okay? So there's a whole bunch of things that you can do, okay? Challenge jurisdiction, there's a whole bunch of things, okay? Standing nips it in the bud before it even becomes a case. If there's no standing, there's no case. Section 15, as used in this act, the term United States means government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. That's the Gold Reserve Act of 1934 at 48 Stat 337. So, again, Federal Reserve notes are meant for the government only, okay? That's corporate, okay? You have to understand that that's corporate. Once you understand that and you start pointing that stuff out, they can't demand lawful money. All they can do is the Federal Reserve notes, and that's all corporate. That's corporate profits. It's all denominated in Federal Reserve notes. There's Supreme Court rulings that talk about it. My new book is now available, Trump, a True American Patriot or Not. Mike Blackwell asked me to write the book. He helped finance the book, actually. But what happened is I just took a lawsuit and manipulated it and turned it into the book. So it's 99% provable facts because I use all sorts of court cases and law dictionary definitions and things like that to support what I say. There's a little bit of opinion, and I say when it is my opinion, I say it's my opinion. And then it took me about 6 weeks to write the book, and then Mike asked me, after Mike asked me, it took me about 6 weeks, and then Mike had to babysit me through the process of getting ready to publish as a book, and that took about 6 months. And so I put him on a book to make sure that he got compensated for it, and because he put a lot of time and effort into it, but I wrote the book. He just babysat me through getting it ready to publish. Now, the people that wrote, he hired a company that helped us with this, and so they put this stuff on the back, and I think that this just nails it. So I'm just going to read. So this wasn't Mike, and that wasn't me. It says, for too long, a small group in our nation's capital has reap the rewards of government at the cost of its citizens. Washington flourished, but the insiders refused to share in the wealth. Public politicians prospered, but allowed our jobs to leave and our factories to close. Not anymore. Okay, that's actually quoted from Trump's speech, his inaugural speech. It says, but not anymore. In Trump, a True American Patriot or Not, Glenn Fern and Mike Blackwell reveal the depths of corruption, deceit, and manipulation infesting our political system for hundreds of years, regardless of political affiliation. Read the hard evidence that exposes how our elected officials sold Americans into slavery. Understand the Founding Fathers' true intent when they formed our Republican form of government. Discover the influence of the satanic Roman cult on our politicians and political system. Does Donald Trump want to transfer power back to we the people? In Trump, you will see the great battle that is upon us. And ain't that the truth? I think they nailed it there, I'll tell you, man. So you can order the book from Amazon or from my website. It's $40 plus shipping. I prefer you order the book by website. I do not accept PayPal. Okay, PayPal is seizing my compensation. Matter of fact, I'm getting ready to. I've already filed a bunch of criminal complaints. I'm going to break it off in their ass. But the bottom line is I do not accept PayPal. There's other ways that you can pay me. Cryptocurrencies is the best, but you can do cashapp. You can do Zelle. Okay, Zelle is free, and that's great if your bank does Zelle, and that's free for everybody. Amazon.com does not provide autographed books. If you want the book autographed, order the book on my website, but don't forget to let me know what you want the autograph to say if you have something you want it to say. Do you want to know the origins of the deep state and who is behind it? Everything in there is provable. Okay, that's why I like using court cases and stuff, law dictionary definitions, international treaties. Do you want to know why it's called the Trump administration? Do you want to know what an administration is? Do you want to know how Trump came to be president? Do you want to know who owns Congress? Did you know Congress is owned? That's why Pelosi gets up there, or did get up there and say, we can't read this bill until after we pass it. Okay, so That's because she's being told what to do. Do you want to know why they're called law enforcement officers? Okay, they're enforcing the martial law. Do you want to know how you have become a slave? Well, first of all, as part of it's Federal Reserve notes, okay, the fake money. I mean, think about it. A Federal Reserve note is a bill of credit, a bill of United States credit drawn on the Federal Reserve Bank. So then think about it. If you're buying something essentially on United States credit, who owns it? United States owns it. Okay, think about it. It's just nothing but a scam. Anyways, don't get me going. You're going to get me going here. Do you want to know what the root cause of the War of Independence was? It's in the book. We're going to talk about it here actually a little later in this video. We'll talk about that. Do you want to know why every president goes to visit the pimp? Well, I meant the Pope. No, I meant the pimp. On the first international trip. It's in the book. Yeah, so I already told you about Mike Blackwell, but Jerome Corsi, I don't know how many of you remember who Jerome Corsi is or have heard of him. He's a guy that lives up in the Northeast. He's got a PhD in political science. He's written a bunch of books. He's got a website. He's got a YouTube channel. Anyways, remember we asked, do you want to know how Trump came to be president? Well, this will answer it, at least part of it. Jerome Corsi, there's a YouTube video where Jerome Corsi says that in 2015, 5 generals came to see him, and they said they were going to overthrow Obama. And he said, well, you can do that if you want, but you might want to go talk to Donald Trump first. And 3 months later, he gets a phone call. They decided not to overthrow Obama because Donald Trump had agreed to run for president. So I think that nails it. That tells you part of how he came to be president. Okay, there's it's 95% provable facts. There's some opinion. Now, some of my opinion, and some of this I've actually learned subsequent too. Okay, but Howard Hughes. One of the things I say in the book is it talks about how I think that all billionaires, they get approached by the New World Order crowd and they get told you're going to go along with our program or you're going to turn up dead. It's kind of interesting that after Bill Gates went to see Warren Buffett, all of a sudden Warren Buffett donated a whole bunch, like billions of dollars, to the Gates Foundation, and you know what Bill Gates is doing with all of that, and so it's a good example of that. Anyways, at the time I wrote the book, I thought that the reason Howard Hughes was hiding out all the time is because he was afraid he was going to get killed, and because he didn't want to go along with their program, and so he was hiding out. And I think the same thing happened to Donald Trump too. Matter of fact, I've got, it's, again, I have no proof, but it's pretty good evidence, in my opinion. There was a helicopter crash in 1984, and Trump was supposed to have been on that helicopter, and 3 of his executives were on it, and they all got killed. The thing about helicopters is all they got is keeping that thing up in the air is those blades, and it's something like what happened, according to the stuff I read, is the blades came off. Well, then you might as well just, there ain't no parachutes, there ain't nothing. I mean, helicopters not designed to crash. You're not going to do too well if something like that happens. And so, yeah, there was a helicopter crash, and 3 of his executives got killed, and he canceled out at the last minute. And so I think he knows exactly what the threats are. And he still did it. I mean, you got to say, that says a lot for the guy. Now, David Wilcock, he's actually got some videos out there, and he talks about how this actually confirms a little bit about Howard Hughes. He says in his videos that after World War II, Howard Hughes, everybody knows Howard Hughes was like, he had all of these, he built the Spruce Goose, he was getting all these defense contracts, building all sorts of stuff for the government, and all of a sudden he got blackballed. And he didn't know what the heck was going on, but he went and hired a bunch of nice young ladies to go and sleep with the New World Order crowd to find out from Pillow Talk what the heck they were doing, why he was blackballed. and they found out that they were planning on doing what they're doing right now. And so they wanted to kill off about 80% of us, and turn it into a global plantation and all that stuff, right? And so he had actually had a procedure manual on how to defeat all of that. He had that. It was a set of manuals, and Kennedy was actually implementing some of that when he got killed. And so Kennedy went and circulated $6 billion worth of U.S. Treasury notes. Well, that's like a big, hey, you Federal Reserve guys, you're all done now. You can go away and get lost. We're not doing anything with you guys anymore. And so, that's why Kennedy got killed, I think. And so that actually confirmed about what I thought about Howard Hughes, except that and you would think, if there was a set of manuals that Kennedy was following, then you would think that that they knew, the people that killed Kennedy knew that Howard Hughes had made those books, and so then they really would be looking for him. You know what I mean? So he was hiding out all the time. He was big time recluse and hiding out. He was real careful about who he had working for him and all sorts of stuff, and worried about being poisoned, all sorts of stuff. That's kind of sad. But anyways, so that's the story about David Wilcock. In reality, they're not after me. They're after you. I'm just in the way. So this is Article 4, Section 2. Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Remember, we talked about that. That Balzac versus Puerto Rico talks about that. And if you're subject to the regulations, you are property. And this is the Canadian Ownership and Control Determination Act. It says owned means subject to the regulations. If you're subject to the regulations, you're owned. And then Section 3 of the Government Corporation Operation Act of Canada. Every corporation, for all its purposes, is an agent of Her Majesty and Right of Canada, the bitch. And, of course, it's the son of a bitch, eh? Martial law is a public law of necessity. Necessity calls it force. Necessity justifies its exercise. Necessity measures the extent and degree to which it may be employed. That necessity is no formal, artificial, legalistic concept, but an actual, factual one. It is the necessity of taking action to safeguard the state against insurrection, riot, disorder, or public calamity. What constitutes necessity is a question of fact in each case. That's taken from Black's Law Dictionary, 8th edition. Necessity is the plea of every infringement of human freedom. It's the argument of tyrants, is the creed of slaves. And that's William Pitt the Younger in a speech of the House of Commons, November 18th, 1783. You think this is anything new? This has been going on since the beginning of time. The action of Congress and the passage of the first Legal Tender Act was placed distinctly upon the existing imperative need of government, and the Legal Tender Clause was urged and adopted as a war measure. Well, gee, that sounds like martial law. Juilliard versus Greeman, 1884, U.S. Supreme Court. Article 1, Section 10, Clause 1. No state shall coin money, emit bills of credit, make anything but gold or silver coin a tender in the payment of debts. And there's no lawful money in general circulation since 1965. So they're all de facto corporations then, right? That's why you challenge standing. Where's your standing to talk to me? I'm a man. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities, checks, is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. Okay, so they waive their immunity. When they take those Federal Reserve notes or demand their Federal Reserve notes, they waive their immunity. And you ought to bring that up. So you're waiving your immunity then, is that correct? Clearfield Trust Company versus United States, 1942. Governments lose their immunity and descend to the level of private corporations when involved in commercial activity, enforcing negotiable instruments, as in fines, penalties, assessments, bails, taxes. The remedy lies in the hands of the state and its municipalities seeking remedy. Municipalities are all territorial, remember? We talked about that in Downs versus Bidwell in that earlier case. Said that territories, that municipalities are all in territories. They're territorial. Congress, claiming its martial law power to declare war, suppress insurrections, repel invasions, impose martial law in the United States, and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. And that's taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court in the case Diet versus Turner, 1968. The 14th Amendment is an extension of national military powers presently used in a municipal character, enforced by municipal laws stretched far beyond their original limitations and enforced by Article I tribunals. That's, again, taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court in the case Diet versus Turner. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury. So think about it. In cases affecting both life and property. So that's why the War of Independence, because they imposed martial law and they got rid of trial by jury. And so it was a kangaroo court. To supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial, for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. Okay, that's dictatorship, folks. And that's taken from the Cause of Necessities for Taking Up Arms, 1775. And here it's here again. It's here. I mean, trial by jury. I mean, most people have no clue what that even means. The refusal of King George III to allow the colonies to operate an honest money system which freed the ordinary man from the clutches of the money manipulators was probably the prime cause of the revolution. Yep, I would say so. And the martial law that resulted. Okay, it resulted in martial law. The United States shall guarantee every state of this union a republican form of government. Well, that ain't happening. Article 4, Section 4. Despotism or republic, a dictatorship or republic. A republic is of, by, and for the people. And so we the people we're just going to have to stand up and say, enough of this crap. That's why what you're having, and that's one of my upcoming videos, is the fruits of a democracy. Because right now we're seeing the fruits of a democracy. That's exactly what we're seeing. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, and interfering with their relation to each other. The powers of the government and the rights of the citizens under it are positive and practical regulations, plainly written down. The people of the United States have delegated to it certain enumerated powers and forbidden it to exercise others. The purpose of a republican form of government is to shield we the people from international law. Copies of these documents can be found on my website and linked under my recent videos. For a complete set of YouTube videos with private information shares, a DVD with over 100 searchable law dictionaries. I went and when I got them, they weren't searchable, but I made them searchable. And when you start doing keyword searches, it's amazing what you find. and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the fake money, the military script, the Federal Reserve notes, the PayPal gifts. Of course, I ought to take that one out of there because I don't do PayPal. They're going to get sued, but I'm going to delete that account. There we go. Checks, money orders, etc. Send me an email for particulars. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's the dissenting opinion in the case Downs versus Bidwell. And that Downs versus Bidwell case just has a load of really good stuff in it. Articles of Confederation, 1781. Article 1 says the style of this confederacy shall be the United States of America. And then look at that passport. It just says United States of America. Matter of fact, that's all you'll ever see. Side of Air Force One, United States of America. A passport is a written document given to a person or persons by a commander of belligerent forces authorizing him or them to travel unmolested within the district occupied by his troops. Passports are issued by the State Department or other similar office in other countries to diplomatic agents or others entering or traveling in foreign countries, which are the same general character as those issued during war. The latter should, when practicable, have the photograph of the bearer attached. And that's taken from the Law of Land Warfare, 1914 edition, Passports, Safe Conducts and Safeguards, and Cartels, Chapter 7, Section 4, Article 276, page 100. And look at that. This is actually a silver certificate, but if you look on your Federal Reserve notes nowadays, you'll see the same thing. It says, the United States of America. That's the only place I've seen the United States of America, except on land patents. They also have it on land patents. The United States of America. At common law, only gold or silver were legal tender, and that's a 1820 court case, but they're citing Book 2 of the Institutes on the Laws of England, which is Coke in the 1500s. If you want common law, it requires honest measures. You will never get. These courts are kangaroo courts. That's why the best thing to do is just defeat it right up front, and if they don't have standing, they have nothing. There is a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. Discharge falls under the Uniform Commercial Code, which is private international law. Check out my other videos. Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 8, Do-It-Yourself, How Not to Volunteer for the Selective Service in the Draft, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail 1 and 2, Do-It-Yourself Kangaroo Courts 1 through 24, Canada Border Pigs Playlist, Bar Members and Their Satanic Connections Playlist. This rule does not interfere with the right of the victorious invader to tax the people or their property, to levy forced loans, to billet soldiers, or to appropriate property, especially houses, lands, boats, or ships, and churches for temporary and military uses. That's forced loans. That's what a Federal Reserve note is forced loans. That's General Orders 100, Libra Code, Article 37. Cryptocurrency is not a forced loan. Anything can be used as a medium of exchange as long as we agree to it. It's called barter. My contact information, my blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile as long as it's up, is Sovereign Living. YouTube has tried to take my channel down now, and I'm not even uploading any videos over there anymore. I'm uploading weekly videos on Rumble. And so please like the video and please subscribe to my channel. And because they're all, I'm trying to migrate all my stuff over to Rumble too. But Google is causing me trouble. I got to file criminal complaints against them now too. So, anyways, I have a Facebook community page. I deleted it due to censorship on the part of Facebook. I have a private group on Facebook called Sovereignty International. You know, I haven't even been on Facebook in months, so I have no idea what's going there. I really need to delete it, and I don't want to delete it without banning everybody off of it, because then it will really be deleted. Otherwise, Facebook will still have it, and they'll be making money off it. And I want to stop that. I don't want them to make money off of my hard work. My free list private group is called Administrating Your Public Servants, and I've got a Google private group called Administrating Your Public Servants. Follow me on Steemit at Sovereignty International, Patreon is Sovereignty International, and Rumble is Sovereignty International. Sad will be the day when the American people forget their traditions and their history and no longer remember the country they love and the institutions they cherish and the freedom they hope to preserve were born from the throes of armed resistance to tyranny and nursed in the rugged arms of fearless men. Ain't that the truth? Roger Sherman, signer of the Declaration of Independence. So, law of nations is international law. They're basically convertible phrases. All banks fall under international law. Military dictatorship is international law. Uniform Commercial Code is private international law. All codes, rules, and regulations are international law. Forced loans is probably the single most important thing for a military dictatorship. It makes it so the courts presume that you do not pay a debt. It makes everybody into paupers. Paupers have no rights except what they allow you to have. Gold is the money of kings, silver is the money of gentlemen, barter is the money of peasants, and debt is the money of slaves. Federal Reserve was set up under the insurance laws of the United States. Federal Reserve notes are worthless insurance script. Anything purchased with worthless insurance script is the property of the issuer of the script. Taxes are the fee for using their private money system. The single most important requirement for a Republican form of government is lawful money. Lawful money is not Federal Reserve notes, it's not bank notes, it's not forced loans, it's not discharged debts. Resistance to tyrants is obedience to God. Therefore, non-resistance to tyrants is obedience to Satan. Well said. Don't forget to subscribe to this Rumble channel. Don't forget to follow me on Steemit. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. I'm thinking that YouTube's going to take my channel down for real one of these days, because I'm going to start getting up in their face, quite frankly. And so please subscribe to this channel, and because YouTube's going to take my channel down when I start getting up in their face and suing them and doing all the stuff I'm going to do. This is my YouTube channel. The subscribe button's already clicked. The bell is not clicked because it doesn't look like it's vibrating. Once you click it, it'll look like it's vibrating, and that gives you notifications. What's called proclaiming martial law is no law at all, but merely for the sake of public necessity and circumstances of great emergency, setting aside all law and acting under military power. That's why they have to pass statutes for common law offenses. That's why all statutes are edicts under martial law. We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It's been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And that's taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett to the Utah Supreme Court in the case Diet versus Turner. But actually, common law is here. If we, the people, get off our backside and convene our common law juries, we can have our common law, But most people are too clueless. They're dumbed down with education. They're fluoridated water, and so they don't have two brain cells that are working. And to convene a common law jury is, difficult. There's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and the same enactment provide exceptions to its application. The thing is they never follow their own codes. And so you can break it off in their ass with their own codes anyways. And I do that all the time. Under a military dictatorship, there's no law. That's why they're required to pass statutes for common law crimes like murder and assault. This creates civil law, which creates a democracy. Under a military dictatorship, you have a democracy, and a democracy is international law. That's what they're doing, is their little scam. I have exclusive content available on my website and on Patreon. My website has 2 subscription levels, and I accept cryptocurrencies. Although I don't accept cryptocurrencies anymore. I was going through what was it? Coin. Oh man, I don't accept cryptocurrencies. I can actually. You'd have to email me, and we'd have to do it privately. You cannot do it through coin payments. It's called coin payments. Can't do it anymore. They want all sorts of information that's none of their damn business. Anyways, so my basic subscription level is $49.99 a year for the videos only and $79.99 a year for the videos plus unlimited email consultations. But I'm not a liar. Well, I meant an attorney. No, I meant a liar. But I can't tell you what I would do under certain circumstances and where to find the forms. But remember, these are email consultations. The only power that these New World Order Satanists have over us is through fraud and deception, as my agenda is to expose it for all our benefit, but I cannot fight all the battles. Some of my exclusive content is an Arlington private information share. That's about 9 videos. Land deed training, there's about 3 videos for that. Estoppel certificates training. Foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, and federal habeas corpus training. Revocation of voter registration, criminal complaint training. There's about 3 videos for that, and I probably ought to need to do some more. Lawsuit training, I got 1 video for that. Probably need to do some more. Other training requests, if it's something I haven't already done, or like the stuff that I put there, subscription stuff is stuff that is stuff that, how would you put it? The stuff that should be public, I want to make public. The stuff that's subscription level stuff is stuff that's above, that's higher advanced, I guess you might say. And so, anyways, keep that in mind for training requests. I also have Northeast Private Information Shares videos that are up there. All forms, files, and other instructions are available for free, linked on my videos and my website. All exclusive content's available on my website, and you can buy a subscription there. And Patreon at Sovereignty International. They've been telling people for decades that we're in a democracy. Do you think that's an accident? And then if you think about it, anybody who calls it a democracy is engaged in treason, if you think about it. That's exactly what it is. Whereas taxation by the Parliament of Great Britain for the purpose of raising revenue in His Majesty's colonies, provinces, and plantations in North America has been found by experience to occasion great uneasiness and disorders. Well, no shit, Batman. That from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, assessment, or whatever payable in any of the colonies, provinces, or plantations in North America or West Indies, except only such duties that may be expedient to impose for the regulation of commerce. And that's George III, Chapter 12, 1778. 2 years. 2 years after the after the Declaration of Independence. Well, that's like closing a barn door after the horses get out. Taxes cause the War of Independence. If they can tax you, then you are their slave. You're forced to work for them for nothing. Think about it. It's becoming more and more difficult to be free. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be pronounced as self-evident. It's obvious. The sovereignty of the state extends to everything which exists by its authority or its permission. And that's McCullough versus Maryland, U.S. Supreme Court, 1819. A subject is a slave. Taxation is slavery. There's two ways to conquer and enslave a nation. One is by sword and the other is by debt. When acting to enforce a statute and its subsequent amendments to the present day, the judge in municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely acts as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. That's why you need to challenge standing. That nips it in the bud right there, because they always attack you with their corporation. It's the accepted rule, not only state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for clerk for the agency. Judges who become involved in enforcement of mere civil statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. So challenge standing. Nip it in the bud. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there's no jurisdiction, there's no judge. The proceeding is as nothing, such has been the law from the days of Marshal Saya. And that's a federal court case, Manning versus Quetcham, quoting Bradley versus Fisher, which is a U.S. Supreme Court case, and that one is quoting 10 Coke 68, which is Coke in the 1500s. So this is as old as time itself. A judge wears a military uniform. The judge sits there and plays stupid. If you fail to follow some obscure rule or procedure, they sell you into slavery. Everything they do is a fraud and a nullity. That's why you challenge standing. Don't bother with the jurisdiction. Challenge standing. They don't have standing. Well, where's their authority to talk to me? Nip it in the bud. Otherwise, you're going to be subject to this. Judge works for the state. Prosecutor works for the state. Police or witness works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or ex reis can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. That's exactly right. Challenge standing. Nip it in the bud. They got nothing to say to you. But in fact, in law, such statutes are intended to be applied to those who are here as residents in the state under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment. That's a summary taken from United States versus United Mine Workers, 1947, U.S. Supreme Court. Neither slavery nor involuntary servitude, except as punishment for crime whereof a party shall be duly convicted, shall exist in the United States or any place subject to their jurisdiction. That's why you want to challenge standing, because that'll nip it in the bud. Otherwise, they're going to turn you into a slave, is what they'll do. They're nothing but thieves and pirates. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state. That's what they're going to do, is they're going to enslave you. Challenge standing. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. They need to be put to death. If we were Christians, okay, that's what would happen, okay? They're assaulting you with that person, okay? In Job, it says you're not supposed to accept a person, okay? It's necromancy. These people are necromancers. They're Satanists. And so we shouldn't even be in there. They're Satanists. Put the evil away from among us, folks. This Constitution and laws of the United States made in the pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. I don't care what your state codes say. The supreme law of the land says that I'm entitled to a trial by jury, and either provide a trial by jury or dismiss this matter. We can have a benevolent dictator or a tyrant dictator. Obama was a textbook tyrant. He really was. Pelosi gets up and tells the House, we can't read this bill until after we approve it. Okay, that's a fall of the tyranny. That's tyranny. Lindsey Williams. You know, I don't know how many of you remember Lindsey Williams. Okay, Lindsey Williams. Haven't heard from him in a while. He's getting pretty old, so I hope he's still with us. He was a Southern Baptist preacher back in the 90s and the 80s, I think, even when they were doing that Alaska oil pipeline. And he went up there, and they went and liked what he was doing, so they gave him quarters on the oil pipeline facility, and they invited him to their board member meetings and did all sorts of stuff. And so he got to know some of these movers and shakers, some of these New World Order crowd, the elite, and they've been telling him for years what they were going to do. And so he was telling everybody else what the elite are telling him. And so he said that the elite told him that when Trump got elected, God intervened. And the elite also told him that when Trump was out of there, that they were going to go right back to doing what they're doing. And hello? That's exactly what's going on. We, the people, are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who would pervert the Constitution. Rebellion to tyrants is obedience to God. That was Jefferson's seal. Rebellion to tyrants is obedience to God. It's time to get unplugged, folks. It's time to get unplugged. Can you hear this? Let me turn it up. All executive orders or regulations for properties are slaves of the government and therefore a color of law. Color of law is something that looks like law but isn't. It is a felony to violate your rights under the color of law. They can violate your rights as long as they can claim good faith. Tell them it's a felony and have witnesses. They always claim good faith. Okay? Build a case against them. And they have lots of good statutes and codes. That's why we're seeing all this corruption. This is all part of a democracy because remember, we talked about it, where under martial law, there's no law. Under common law is the unwritten law. Common law, you can do anything you want as long as you don't damage someone's person or their property. And that's all it is to it. It's simple. And so they don't, there's none of this complicated. What they do with these codes is they pass all these codes, and there's literally millions of codes, and who can possibly know them all? And so then and that's where I can break it off in their ass, because they never follow their own codes. But that's also where they can engage in all this corruption, because they're doing all of this corruption that's going on is because of the millions of codes. They get to know a few codes, and they go and follow these codes, and we don't know about it, and they're nothing but a bunch of thieves and pirates. America needs God. Rebellions to tyrants is obedience to God. It's time we went and started to repent, really, is what it comes down to. Thou shalt have no other gods before me. The New World Order will require you worship the government. That's going on in China right now with the Falun Gong. They're doing their organ harvesting programs. If you don't worship the government, then they harvest your organs, right? And they don't even put you to sleep when they do that. They just go ahead and put you on the table, tie you up, put you on the table, and start harvesting your organs while you're alive and conscious. If you're being forced to sign anything, put without prejudice over the signature. Actually, I just put it right there. I don't even sign it. If you're going to sign it, put the without prejudice before. There's a friend of mine, Kevin Hines, who told me that the federal judge told him back in the 90s that putting without prejudice there means there's no signature. And I've got evidence, I got proof of that because I've done it too with the federal judge, and they would say it's unsigned. And sometimes they refuse to allow you to put without prejudice. I've never had any trouble, quite frankly. They make an affidavit at the earliest opportunity and attach it to avoid judgment. Every consent involves a submission, but a mere submission does not necessarily involve consent. That's a maxim of law. When they have you in their jail and give you something to sign, they're wanting you to pay for your own imprisonment. If you refuse to sign it, it's a commercial dishonor. They'll write in refused, and it's signed, and you paid for your imprisonment. If you write in there without prejudice, then there's no signature, and they're not getting paid. We need to be staying out of their so-called courts. We need to challenge standing. We need to be convening our own common law juries. In suits at common law where the value in controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. And that's in the 7th Amendment, okay? It's powerful, really, really powerful. So in our common law courts, all we do is we decide what the facts are. And it's very hard for them to undo that. So let me just put in another one here. There we go. That's another one. Upcoming videos. Clean hands. Legislative courts. Article 3 courts. What's an Article 3 court? YouTube deleted my channel again, so I was going to go through and talk about what happened and what I did. The right to keep and bear arms. IRS authority. Where's their authority? How do you deal with the IRS? And how I've done it. This is stuff that I've actually done that has actually worked pretty good. The fruits of a democracy. Okay? So those are upcoming videos. Now what we're going to do is we're going to go through standing, how to challenge standing. And so what we'll do is we will I've got some generic documents that I prepared. And this is the first one. What I'm going to do, I'll probably upload these to Google Docs and then put a link under this video. I'll try that, see what happens. That way I won't have to be emailing the people. Anyways, you got to send it by certified mail. And notice the Great Falls Municipal Court is 123 Cheater Street. And then the prosecutor, Dewey Shyster, Dewey, Cheatham, and Howe, on 456 Cheater Street. And so the cause number, State of Montana, Inc. versus John Henry Doe, defendant in error. The Supreme Court of the United States has stated that no corporation is standing to say anything to a man or woman. And then you have the quote that we put there. The defendant in error requires the state of Montana prove their standing to proceed against a man in any court of law. You have 14 days to prove your standing or forever cease and desist. And sign and seal in red ink on the land under penalty of perjury. I declare I've scribed and read the foregoing facts. And so that's it. It's a one-pager. That is a one-pager. Okay? That's what I like about this. This is a one-pager. It'll take them 2 minutes to read this thing, and they'll never respond. Okay? They can't. They can't. And so after 14 days, what you do is you send them, let me pull that one up. You send them the notice of default. Wow, what's happening here? How come we're not... What's going on here? How come it's not showing? Weird. It's showing on me, my software here. I'm just... That's weird. What the heck is going on here? Okay. What's going on? How do I get this thing to transition? Weird. Some reason this thing doesn't want to transition onto these other documents. I'm seeing it on my that is weird. Okay, wow. Okay, so I'll just have to read it and then I'll upload the file. I don't know what's going on here. I got to figure it out. That is really weird because that's not even the PowerPoint slide that I'm looking at. That is weird. Wow. Okay. Well, I could spend all day dicking with this thing, so I'm just going to go ahead and read this next one. So the notice of default. The next one's a notice of default, and it's certified mail. And notice of default. You failed to provide evidence that you have standing. This is after 14 days. You failed to provide evidence that you have standing to proceed in any court as required. Therefore, by your acquiescence, you've admitted that you have no standing to say anything to any man in a court of law. In this case, is a fraud and a nullity, and evidenced by the challenge to standing served on you on this other date. And a true copy of which, together with proof of service, are attached here to, all of which are incorporated herein in their entirety. You have 5 days to dispute this fact by providing evidence of your standing to say anything to a man in any court. And so you give them another 5 days. And so then it's all signed under penalty of perjury. So that one's actually a little bit more than 2 pages, but not much. And then the last one is weird. That's not showing up on there. It's not transitioning for some reason. Oh, hold it. What happened there? Nope. Weird. So then the last one is a final notice of default. So it's a 3-step process. The final notice of default says you failed to provide evidence that you have standing to proceed in any court as required. Therefore, by your acquiescence, you've admitted that you have no standing saying anything to any man in a court of law. In this case, is a fraud and a nullity, as evidenced by the challenge to standing served on you on this day, and a true copy of which, together you with proof of service, are attached here too. And you had 5 additional days to dispute this fact by providing evidence you're standing to say anything to a man in any court, and you failed to provide such evidence. Therefore, this is a final notice of default, and you have proven that you fail to have standing against the defendant in error or any man in any court, as evidenced by this notice of default, this final notice of default that was served on you on this day. True copy of which, together with proof of service, are attached here too, signed and sealed in red ink. And that's it. So that's like 2 pagers. So there's, and then with your evidence, you're going to have to attach evidence. So I don't understand why that is doing that. And that's not even looking on the latest slide. I don't understand what's going on here. Okay, so that's weird. All right, well, that's about it then.